Ms. Edwards, can you hear us?
Yes, good morning. I can hear you.
There, very good. Thank you, ma'am. And Miss Early is just listening in. Is that correct?
Yes, ma'am.
Okay, very good. So I hope you all heard me say that now is the time in the proceeding that I'm going to swear everybody in who's here to testify. So that includes the people who are on the computer appearing on behalf of their clients or the clients themselves. So if you're here to testify on any items, if you could stand if you're able and raise your right hands for me. That includes anybody in the room. Are you folks here for a code enforcement agenda item? Okay. Stand, raise your right hands. Raise your right hand, sir. Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth? All right, with that, I will turn it over. Let me just, a few process notes. It looks like based on the agenda, with the exception of one hearing, everything is violation or fine assessment hearing. So the way that will work is you'll hear the case called by the town. They'll either stay in their seats. Looks like they have enough microphones to stay in their seats this morning. They'll present their case from their seats. You'll go to the podium that's here on my right side. Once the town is finished putting on its case, presenting any evidence, any witnesses that it has, you will then come to that podium and you will have the same opportunity to present any witnesses that you have, cross-examine any witnesses that the town has called, show me any documents that you have, say to me anything that you'd like to testify to verbally. At the end of that, I'll make a ruling, and ultimately you'll get an order in the mail that reflects that ruling. Keep in mind, I just swore all of you in, so your testimony here today is given under oath. So keep that in mind as you testify. With that, I'll turn it to the town to call its first case.
Okay, we have additions and deletions. We have deletions. We'll be removing item 4 for Lantana Holdings LLC.
Okay, so you're pulling that from the agenda?
Yes, ma'am.
Okay, very good. Thank you.
And at this time, our first item is item 3 under foreclosures. The property owner's name is Eldad Itzkovich, and that's at 1032 Hyde Park Road of Waxahachie Groves, Florida. And this is case number 202006122, 22050001, 23080004, 23090001, 2305031, 2300005. Those are the case numbers.
And who's doing the presentation? Go ahead, sir.
Good morning, ma'am. My name is Anthony Neonakis, and I've been sworn in. I'd like to submit the case file for exhibit A, if that's okay.
Sure. Do me a favor, just spell your last name for me so I get it right in the order.
Neonakis.
Thank you. All right, go ahead.
I'm a code compliance officer for the town of Waxahachie Groves, Florida. This case concerns the property at 1032 Hyde Park Road in the town of Waxahachie Groves, Florida. According to the Palm Beach County property appraisers records and Palm Beach County tax collector.
I'm sorry to interrupt you. Let me just make sure. I think that the person on the computer, get that microphone a little bit closer to you because I'm having a hard time. So I
Yes,
just want to make
ma'am.
sure that she can hear you if that's
Yes,
who's
ma'am.
here for this case. Thank you.
Palm Beach County Tax Collector's Office. The current owner of the property is Eldad Itzkovich. This case is a request for authorization of foreclosure or to sue to recover money judgment. The cases in reference are 20206122, 22050001, 23080004, 23090001, 23050031, 23030005. In the previously mentioned cases, findings of fact were found, orders assessing fines issued, and the following cases were recorded with the Palm Beach County Clerk of Court. Case number 2020606122 was recorded on July 11th, 2024 under book number 35135, page 72, has been recorded for more than 90 days, remains unpaid, and as of February 3rd, 2025, the amount owed is $141,900. Case number 22050001 was recorded on July 11, 2024 under book number 35134, page 1718, has been recorded for more than 90 days, remains unpaid as of 2/3/25. The amount owed is $198,250. Case number 23030005 was recorded on May 18, 2023, under book number 34309, page 265, has been recorded for more than 90 days, remains unpaid, and as of February 3rd, 2025, the amount owed is $165,250. Case number 23050031 was recorded on July 11th, 2023, under book number 34423, page 1253, has been recorded for more than 90 days, remains unpaid, and as of February 3rd, the amount owed is $153,500. Case number 23080004 was recorded on October 23rd, 2023, under book number 34625, page 253, has been recorded for more than 90 days, remains unpaid, and as of February 3rd, 2025, the amount owed is $121,250. Case number 23090001 was recorded on September 21st, 2023, under book number 34571, page 618, has been recorded for more than 90 days, remains unpaid, and as of February 3rd, 2024, the amount owed is $269,000. The total amount of the fines as of February 3rd, 2025 are $1,039,150. As of February 3rd, 2025, the property remains in non-compliant status and no permits have been issued. On January 23rd, 2025, the notice of intended foreclosure hearing was served on the property, was sent by certified mail on January 23rd. And on January 23rd, the notice was also posted on the property and at Town Hall. Additionally, the notice was mailed first-class mail, the United States Postal Service, on January 23rd, 2025, and the green card was returned. An affidavit of service is included in the code enforcement file. Subject to any questions you might have, this concludes the town's testimony.
Okay. And there's a signed green card in here. Is that for the foreclosure notice? Okay.
Yes, ma'am.
So the town is seeking today authorization to foreclose?
Yes, ma'am.
And to clarify, Your Honor, this is Ben Saber, Town Attorney. We're seeking both authorization to foreclose or to file a action for a money judgment. So the town wants to have the options to do one or the other.
And where's your authority on the latter?
That's also under section 162.09C. So both for an authorization in order to file a foreclosure action or an action for a money judgment, both of them require authorization from the special magistrate.
Perfect, thank you. And you said somebody is here, is the person on the computer is here for this case, is that correct?
Yes, Miss Edwards Walpole, I hope I'm pronouncing her name correctly, is here virtually on behalf of the respondent. And the property owner is here as well in person.
In person? Okay, who is that? Okay, you're gonna speak or no? Okay, very good. All right, is it Edwards Walpole?
Yes, good morning. For the record, sorry, I would be there in person, but I'm sick. Katie Edwards Walpole, Law Office of Katie Edwards Walpole, 300 South Pine Island Road, Suite 201, Plantation, Florida, 33324. I represent the respondent and the property owner who's there in person today, Mr. Eldad Istovich, 1032 Hyde Park Road in Loxahatchee Groves.
Okay. I guess let me ask the town, before I hear your side, ma'am, let me ask the town a procedural question. Since you have a remote appearance from an attorney, did you provide her with the case file in advance of this morning's hearing?
I did not provide her with the entire case file. She has all the orders that are in the case file. I believe the only other things in the case file are the affidavits of service, the green card. I believe maybe there's some information from the property appraiser's website, but she does have all of the orders that are at issue.
Also, for the record, ma'am, I spoke with the property owner this morning and offered him the opportunity to discuss the case and to go over the file, and he declined.
Okay. Ms. Edwards Walpole, typically what happens in these proceedings, and I understand, I appreciate you not coming to the hearing if you're under the weather. But typically what happens is the next part of the process is I would show you or your client the evidentiary case file that the town is asking me to enter into the record. The town is telling me that you have copies of the certified mail. Is that correct? Excuse me, of the certified copies of the orders. Is that correct?
Thank you. And thank you to the town attorney, Saver. I was engaged last week to represent the property owner. I did put in a public records request for each of these cases to have the full and complete file there. I know the town clerk's working on it, and I did receive copies by email from the town attorney. I have copies, they're not certified, but what was recorded of the orders finding violation and of the lien. So I was provided those by email late last week. However, in terms of the full file from the town, no, I have not received that yet. And certainly am able to access information from the property appraiser's website. We have a copy of that and of course can submit that as well into the record. But to answer your question, that's what I received from the town.
So how does the town attorney want to proceed?
Why I would suggest, I think the only thing she has not seen are the town's documents showing that notice of this hearing was properly served. We both have the property owner and an attorney here. I don't think there's a question about whether or not we served the notice of hearing. So I would ask you, Special Magistrate, to please accept our composite Exhibit A. If someone else wants to see anything else, if the property owner would like to look at it, we have no objection to that.
So, Ms. Edwards Walpole, the issue that I'm having is that there's additional documents in the case file. Your client is here. Is it an opportunity for your client to, or is it an option for your client to review the notice documents? I mean, I have a signed green card, so it looks pretty clear on service, but given the fact that you're on the computer and this was not provided to you in advance, I just want to make sure that you're able to see it. The other thing we could do is recess this case for a few minutes and have the town scan this to the attorney that's on the computer so that she can see it. I have to get over the fact that, or I have to get on the record the fact that the documents have been reviewed, and given that her appearance remote was allowed, I think we need an opportunity to present the documents to her. So Ms. Edwards Walpole, would you prefer that the documents are emailed to you, or would you prefer that your client review them in person?
Just for the record, since we are here and we're appearing and he's there in person on the issue of notice and service with the town, we would ask that you go ahead and acknowledge, and we will too, for this point, that's been satisfied.
Okay, so no objection as to the legal sufficiency of service for this morning's hearing.
Correct.
Okay, I appreciate that, ma'am. Thank you. Go ahead with anything else you'd like me to hear. You heard what the town said. You've heard what they're asking me to order today. So now it's a chance for you to respond to that.
Thank you very much. And first, again, thank you to the town's attorney for working with me late last week to provide as much as I had requested for the record, and we can provide this. My assistant is there in the audience to submit. We've got copies of the orders that have been recorded with the clerk's office. I don't believe that they're marked as certified, but we would like to at least have that submitted and reviewed just to review whether or not the statutory requirement of recording a certified copy on that issue first has been satisfied. And Barbara's got copies of those that she can provide for the record.
Okay. I believe she's approaching now.
Ms. Edwards, I want to make sure I have the right documents here to give to the special magistrate. I know there are a few letters that you had sent me this weekend, and I did review them this morning before the hearing. I believe these are paper copies of them. One of them is regarding case number 2205001, and another of the letters is regarding case number 23030005.
Just for clarification, since I'm not there, Barbara, I had run a title search report late last week. So what I'm making sure that she's providing the right thing. I'm not looking to introduce the letters separate and apart that I had sent to the attorney. I don't want those introduced right now or into the record, but I am just looking for her to give you the copies of what was recorded with the clerk as it relates to the code enforcement cases. So there should be the recorded copies of the order finding violation. And then I believe the second ones would be the related to the liens. There should be copies from the clerk's
Yeah,
office
thank you. And
for these cases.
I'm just doing a quick flip through right now.
All right, so Miss Edwards Walpole, go ahead, I'm sorry. Mr. Saber, go ahead.
And I'm sorry, I just want to say the town doesn't object to this evidence. Regarding that, it says not a certified copy. These were downloaded from the public record site. These are, in order to get certified copies, you have to pay an extra fee. You know, these have been recorded. We had the testimony. I think the evidence is sufficient to establish as a matter of fact that these have been recorded on the date stated on those orders.
All right, so no objection from the town to the entry of these documents.
Correct, Your Honor.
All right, and Miss Edwards Walpole, just so the record is clear, I heard your statements with regard to stipulation as to service, but I just want to make sure there's no objection to the town's entry of its evidentiary case file, which includes the service documents for this morning's hearing, a property appraiser printout showing ownership. There's a warranty deed dated January 12th, 2028, recorded at book 29584, page 939. There's the notice document for this morning's hearing. A photograph showing the posting of the notice document, 3 photographs showing the posting at the property, an affidavit of service for the notice document. And then all of the certified copies of the orders. Orders assessing fine that were recorded in the public record. No objection to entry of the evidentiary case file?
No.
Okay, thank you. All right, go ahead, Miss Edwards Walpole.
Thank
So I have
you.
your exhibits in front of me.
Okay.
And let me just, for the record, let me mark, I'm sorry to interrupt you. Let me mark, as I normally do, the town's composite exhibit 1 without objection. I'll mark respondents composite exhibit R2. And I'll keep, I presume these are copies I can keep in the case file for the town. Is that correct, Ms. Walpole? Edwards Walpole, I'm sorry.
That's okay. Calling Miss Edwards if that's easier. No objection on that point.
Okay, thank you. With that, I'll enter that composite exhibit R2 without objection. Go ahead, ma'am.
Thank you. My point was as it relates to section 162.093 of Florida statutes, where it says a certified copy of an order may be recorded And that was simply what I was looking for, a finding just to make sure that there is compliance with that portion thereof. I understand the difference between requesting a certified copy, but if I read this correctly, it's a certified copy of the order imposing a fine or a fine plus fair costs, et cetera, that may be recorded and thereafter shall constitute a lien against the land. That was a
And this
certified order.
And Miss Katie Edwards, I'm sorry about that. I didn't quite understand. So that portion, town's position is that portion of the statutes referring actually to the town clerk's certified stamp. And so all of those you can see, I think it's usually on the second page of the order. There's a certified stamp from the town clerk stating that's a certified copy. And then that was recorded in the public records. And so the versions of these orders are not certified by the county, because we didn't pay the extra money to get that. But the certified copy in the statute's actually referring to that stamp from the town clerk. That's on all of those orders.
Thank you, and I appreciate that clarification, and just again on that point, a finding for compliance on that, that was simply what I was seeking.
Okay, anything further you'd like me to hear?
On that point there as well, and again, Barbara, if you got it, the property information report, and this was previously provided, albeit late yesterday, to the town's attorney, the printout from the Palm Beach County Property Appraiser's Office to show that the property does have the Save Our Home status. So unless there's objection, she has paper copies of those. I know the town also submitted the property record, but this would be offered just for that purpose to confirm at least the property appraiser status and that the Save Our Homes base year is 2019. And it's also currently in effect for 2025.
So I'm looking, the town didn't have any objection to the property appraiser printout, which looks nearly identical to what is in the case file already, but I'll go ahead and add that to the respondent's composite exhibit R2. So your argument is that the property is homesteaded, is that correct?
That's correct. Not so much an argument, but just a finding. So it's there for the record.
And what's the town's response?
Your Honor, I'm going to kind of have a two-part response here. Yes, we recognize that according to the property appraiser's website, this is homestead. I think our first position is that the language I think she's referring to in chapter 162.09C, that language is talking about when you file a lawsuit, and the town's position is that doesn't apply here. Here, really, the only thing the special magistrate should be looking at is there a certified copy of the order and has it been recorded for more than 3 months? Those have all been, we've shown that we've met those requirements, and therefore we're entitled to authorization to foreclose or to file a money judgment. So that's our main position. But secondarily, we want to point out that under the Constitution, when you have property that's located within a municipality, homestead protection only applies to 0.5 acres. However, as you can see from the property appraiser's website, this property is actually 5 acres in total. Therefore, this entire property is actually exceeds what you can claim as homestead. And I have case law showing that in these circumstances, it indicates that yes, municipalities can foreclose on properties when it is more than 0.5 acres.
And
And I'm happy to provide copies of that case law if you would like that. But again, the town's position is that this issue isn't really an appropriate issue for this hearing. Those would be the types of issues we would have to figure out if the town decides to move forward with a lawsuit.
okay. All right, Ms. Edwards, go ahead with your response.
And thank you. And I understand the distinction and bifurcating the town's ability to maintain the foreclosure or the lien. I'm kind of in a speak now or forever hold your peace mode to make sure at least at this hearing that it's noted and it's on the record. And hopefully we don't get to a point where there is suit, but if the town is seeking requests for authorization to foreclose or to seek money judgment, I would at least like that information reflected there on the record.
Okay, anything else you'd like me to hear, Ms. Edwards?
Thank you. I think there was a, just a finding regarding the statutory caps. That the caps, phrase this the right way, the amount of the daily fines and those judgments, just a finding on the record that they comply with statutory authority based on the town's alternative code enforcement hearing structure under 162 and so forth. So we would just be looking for a finding that if they do proceed, that those caps are within the guidelines set forth in statute.
And when you say caps, explain to me what you're
Sure. For
referring
example,
to.
thank you. For example, if the maximum daily fine for a first offense is X amount, that's what we have in front of us. So I just want to make sure that we point back to the authority and make sure that this won't be an issue that comes up again.
Well, I guess it isn't, I guess I'm not sure that that's within my purview this morning. I mean, the request before me this morning is strictly one of foreclosure authorization. If you had a legal objection to the statutory amounts or to the, excuse me, the fine amounts imposed under the statute, that would have been a remedy that you would have needed to take up on appeal of those orders, correct? I'm not sure that that's within my authority this morning, based on the way that this has been noticed and the way that it's on the agenda this morning. So I'm not sure that a factual finding is appropriate on that at this hearing.
Okay, and we will accept that. I just wanted to at least get that on the record to raise that point.
Okay. Okay, anything else you'd like me to hear, Ms. Edwards?
At this time, no, Your Honor.
Okay, anything else that the town would like to say?
No, I just again to clarify that in the order we're seeking, we want to have the ability to either seek foreclosure or money judgment.
All right. All right, so based on, I appreciate the arguments of both sides. As I was indicating to Ms. Edwards, my authority at this hearing is actually pretty limited in terms of factual findings and authorization, really. I mean, this is relatively simple in terms of proceedings. But the first thing I'm going to do, the one thing I do have to make a factual finding on is legally sufficient service. So with the stipulation by Miss Edwards Walpole, I just want to have the record reflect that the notice documents that are in the case file include a certified mail that was signed for the notice of request for authorization of foreclosure or to sue to recover money judgment. I just want the record to reflect that the town, based on the stipulation of Miss Edwards Walpole, as well as the signed certified mail, as well as the affidavit of service, which was also in the file, that the town has legally sufficient service for proceeding with this morning's hearing. In reviewing the evidentiary case file, which also includes the respondents' exhibits, this one is pretty cut and dry. The testimony of the town and the dates on all of the orders, and there are many of them, so I'm going to actually go through them individually, but the statutory requirements of there having been a certified copy of each order recorded in the public record, that lien has been recorded for a 90-day period, and the testimony of the town is that all the liens remain unpaid. So in terms of checking the statutory boxes, which allow me to authorize foreclosure, or the seeking of suit to recover money judgment, I think that those are all met based on the documents that I'm looking at and the testimony of the town. So just so the record is clear, I'm going to go ahead and rattle off all of these case numbers, just so the record is very clear that in 22050001, the order assessing fine, a certified copy stamp is on that order. The order is dated December 14th, 2022. The order was recorded in the public records of Palm Beach County on July 11th, 2024. And the testimony of the town is that that lien remains unpaid. Obviously, that is more than 90 days from July 11th to 2024 to today, which is February 3rd, 2025. Order 2020-06-122 is an order assessing fine that was recorded. Also contains a certified stamp of the town clerk. It was recorded again on July 11th, 2024 at book 35135, page 72. Again, the testimony of the town is that the lien remains unpaid. So again, that meets the statutory requirements of having a certified copy recorded in the public record for more than 90 days, and the lien remains unpaid. 23030005, again, an order assessing fine, which presents a certified stamp of the town clerk. It was recorded in the public record on May 18th, 2023. And again, the testimony of the town is that the lien remains unpaid. So again, that period of time is more than the 90 days required by the state law. 23050031 is an order finding repeat violation and assessing fine, recorded again July 11, 2023. That order also contains a certified copy stamp from the town clerk. Again, the town's testimony is that that lien remains unpaid. For the record, the period of time exceeds the 90 days required by statute. 23080004, again, an order assessing fine recorded October 23rd, 2023. The order contains a certified stamp of the town clerk. The town's testimony again is that the lien remains unpaid. And finally, 23090001, an order finding repeat violation and assessing fine, again contains a certified stamp of the town clerk. Was recorded on September 21st, 2023 at book 34571, page 618. Again, that exceeds the 90-day period under state law. And the town's testimony is that the lien remains unpaid. So given the status of the documents, the recording status, the status of the liens with regard to payment, I will issue an order authorizing foreclosure. The order will also authorize the town pursuant to Chapter 162 to either foreclose on the property or to sue to recover money damages, a money judgment for the amount of the lien. Given the documents and the testimony of the town, certainly the statutory requirements for foreclosure authorization have been met. So I'll sign an order to that effect today, and Ms. Edwards, I presume the town will get you a copy. The certified mail copy will be sent as is required under state law, but I presume they'll also get you a copy electronically as well. Okay. Thank you for your appearance.
Thank you.
All right, next case.
We are now on item 5A under violation hearings. And the case is with Matthew Otero. And the address is 13327 Marcelo Boulevard, Loxahatchee Groves, Florida. And this is case number 2410012.
Good morning, Your Honor. For the record, Code Inspector John Suarez presenting case 2411012 in reference to the property 13327 Marcelo Boulevard. The notice of hearing was sent via certified mail on January 17th, 2025. The property was posted with a notice of hearing on January 17th, 2025. And there is a posting of the notice of hearing here at Town Hall. There is a signed affidavit of service in the case folder as well as photos attached of the postings. The property was initially cited with a notice violation on November 24th, 2024 for the following violations. Section 111.1, certificate of occupancy, that has been complied. Section 92-010A, site permit affidavit required for any RVs on the property. So upon my inspection, there were multiple RVs on the property, and there is not an affidavit or permit with the town as required by the Muni Code. Upon re-inspection on January 17th, 2025, I also inspected the property on January 28th. The RVs remain on the property. On January 28th, I did speak to the property owner on site. He understood, and he's working with our permitting department to get either affidavit or permit. He has emailed me, and I believe he's here, Your Honor, to request additional time. The town is okay given 45 days for compliance because it's, it's a new permitting, it's a new code, and it's gonna be a new permit for us. It's gonna open it up for inspections if it's occupied, or if they're not occupied, it's an affidavit with the town. And they're limited by the number you could have, depending on the acreage of the property. In addition to my testimony, I offer the town's code enforcement file for the case as well as composite exhibit to be admitted as evidence for further support for the finding of violation for code section 92-010A.
And you said compliance within 45 days, or is there a
Uh-huh.
fine amount you're seeking, and do you have administrative costs?
I'm sorry, Your Honor. There's administrative costs of $234.05 that we are asking for. And in 45 days, if it's not in compliance, $100 a day.
Okay, and you have a case file to present? Thank you, sir. And somebody's here for this case?
I am.
Okay, very good. Can you come to the podium for me?
Yes.
Thank you, sir. And you were here when I swore everybody in, right?
Yes.
Very good, thank you. Just give me 1 second to look over the case file, and then I'll turn my attention to you.
You're on item 5A.
Looking for looks like there's an old notice of violation from November. Is there a new notice in here?
It should be in there, yes. Should have been the front copy. If you don't mind, after. Not, it's no problem to print it out.
No, I don't see it in here.
Should be attested.
All I see is one from November. If you want to look, just to
Just-
make sure I'm not incorrect, but
We'll print it out right now, Your Honor. I'm not gonna remove it, Your Honor. Printing out right now.
okay. All right, let me hear from the respondent, and I'll hold off on entering the case file. So let me just ask you, just so I understand, it's an RV that's there? Is that what you said, one?
There are multiple RVs. I count 3 to 4 on the property. I believe in the pictures you can see 2 on one side and 2 on the other.
Okay.
of the property.
There is not 4 RVs there, Your Honor.
All right, give me your name, sir.
Matthew Otero,
Okay, very good.
owner.
For the record, Your Honor, I did hand Mr. Otero on January 28th the copy of the ordinance and what I have in the case folder,
On what day you handed that to him?
January 28th.
Okay.
Like I said, he has been talking with our permitting department to weigh his options.
So I see one of these is clearly an RV. Can I ask the code officer to come up here and show me what else show me the 4 that you're telling me are there. So that's one, right? So that's not exactly the same as that one.
No, this is 2 sides of the property. So this is the right side and left side there. Because you can tell it's. It's not the same, but they're similar looking RVs.
Okay. All right, but this is what you're considering an RV, none of this other,
No, just the ordinance, how it writes is just RV.
okay, very good. All right. Go ahead, sir. How many you have, you're saying you don't have 4, how many do you have?
No, there was 2, and then there was a little delay with the CO. This is a brand new construction.
Okay,
Town told me that I could have 2 during the construction. So then we were getting the CO. I was told I had to vacate the structure. I put one there for a little bit, for like about a month, I think, while this was going on. I finally got my CO. And then I'm able to move the 1, and then I will register the 2. I just registered because I got my CO with a homestead exemption and the bona fide agricultural. I had
Okay.
a lease for McCoy bees. So that's all in. I have that here. If you would like a copy of it, I could give that to you to put in the file.
what is that? That's a lease
This would be the bona fide agricultural,
of the exemptions?
the
status of the
exemptions and the
exemption.
homestead exemption now, so that I can fall under the bona fide. So I'll have the 2 RVs that I will register, and I appreciate the town giving me 45 days to do that. This is in, this shouldn't take that long. So that will be in, then I'll register them. And then I'll get the 1 off. So,
So when you say this is in, you mean the ag exemption?
correct, the ag and the homestead.
Okay, so show that, if you want that in the case file, show that to the town, before I see it, and let me ask them if they have any objection to that being entered into the case file.
Give me a minute, Your Honor.
And I'm sorry, Madam Attorney, if you want to look as well, go ahead. All right, and then let me ask the town for that notice document as well. The town doesn't have the original of this? 'Cause this isn't signed, I presume you're trying to enter a record here, so. If that's gonna become the original, I would presume your attorney would want you signing that. And let me ask, so was this an old case that didn't get to hearing? Is that what happened here?
No, this is new business. This was started completing by myself.
Okay,
in November.
right, but that's what I'm not clear on. Why did this additional notice go out?
Just for, just to be clear, there was a notice for hearing on the correct dates. I'm not sure if there was a.
Judge Magistrate, if I may, and I'm not certain, but we did have a few hearings where those hearings were canceled. So I'm not sure if the documentation matches that fact up. If perhaps it was scheduled for another hearing date, and then he had renoticed it.
Okay. All right, it sounds like the parties are working together, but just going forward, if you send a new notice of hearing, don't send a new notice of violation, notice of hearing, send a notice of hearing, because you can't do retroactive compliance dates, which is effectively what you've done here. That I'm gonna give him more than enough time so that he complies and this is not an issue, but in the future, when you reset a hearing, don't reset a notice of violation, just reset a notice of hearing. Cause you send him a notice of violation with compliance dates that were already expired based on your prior notice, which is also in the case file. So I'm gonna accept it as sufficient for today, but going forward, please be careful with that.
I understand, Your Honor.
So let me ask you, sir, how long is it gonna take you to get this? Has the town given you any indication of how long it'll take to get this ag classification done?
I went there, the past week. The ag should go pretty quick from what I understand from McCoy's. I've had bees on my property for as long as I lived in Loxahatchee Groves for 9 years.
Okay,
So it should go pretty quick. And that's basically with the county. But they do know the lady that could put it
help
in and.
facilitate
yeah.
that, okay.
And I did ask to expedite that.
Okay. Let me ask Mr. Suarez, can you show him the town's evidentiary case file, which is also going to include your documents? I'm going to keep them separate, just so you can look at that. The papers don't go everywhere, but take a look at that case file, and at the end of it, let me know if you have any objection to those documents being entered into the record.
This would be the two. And then this was the one after, that I put here was after I was given the first one. So just so you know, but yeah, it's fine.
So no objection to those documents being entered, sir?
No, ma'am.
Okay. So with that, just so the record is clear, I'll enter the town's evidentiary case files composite exhibit 1 without objection, and I'll enter, can the town keep this, or do you need?
That's
to keep
yours.
with you? Okay. I'm gonna mark respondents exhibit as composite exhibit R2. And I'm going to, excuse me, admit that into the record without objection from the town. So what is the expected timeline on getting one of these registrations complete with the town? Is it a matter of a couple of days, or?
Once he applies for the permit, it shouldn't take longer than 45 days, but it shouldn't take longer than a week neither. As soon as he applies for the permit, it opens up for inspection. And we schedule it together. Once he passes inspection, he should have his permit the next day.
But is his obtaining the town's approval, is it contingent on this ag classification going through?
It is contingent on the ag classification. You said it was approved by the county?
It's in now, so it should be.
With the county, I'm not sure their time frame for the ag exemption, but it is contingent. The number of RVs is contingent on his ag classification
Okay,
and as well as fees.
okay,
And I've had the bees there for last year, but we weren't CO'd yet. So this would be the next year, 2025. So
okay,
it's been a couple of years.
okay. And the county hasn't given you any indication of how long it'll take?
I could call and just ask.
So I'm gonna give you more than enough time because you've done the right thing. You've showed up to the hearing, number one. You're moving forward toward getting into compliance, which is my ultimate goal. My ultimate goal is not to be punitive. My ultimate goal is that you comply with the town's code. So I'm going to give you, because you have a kind of a two-step process and this one's a little bit out of your control, I'm going to give you a little bit more time than the town is asking me for, just because, again, you're doing the right thing and you're trying to get into compliance as quickly as you can. So with that, is there anything else you'd like me to hear this morning before I rule?
I would like the administration fee to be waived.
Okay.
I'm gonna, and I'm with the town. I love the town, so.
Okay. So unfortunately, I can't do that. The town does have hard costs. If I find you in violation, the town's entitled to that. What I can do is, you know, if you don't ever come back, if you get complied, you never come back to me for a fine assessment hearing. So that stops the incurring additional administrative fees. So, and again, without an order assessing fine, typically I don't think that they're recording those liens. So, but once I find you in violation, if I find you in violation, they're entitled to their costs. So there's nothing I can do on that, unfortunately, because there are hard costs for the town to get here today. They have to pay their attorney to do reviews of these things. They have to pay for time to draft orders and those other legal things. So I appreciate your request, but unfortunately I can't waive the administrative costs for today. The only thing I can do is encourage you to get into compliance by the deadline that I'm about to give you, so that you don't get any more administrative costs incurred, because those do add up. The more times you come to a hearing, the more expensive that becomes. Anything further?
No, ma'am.
Okay, anything further from the town?
No, ma'am.
All right, in case. Two, 411-0012, I've entered the respective exhibits into the record. I'm gonna find, based on the affidavit of posting, that the town had good service for today's hearing. I'm gonna find, based on the photographs in the evidentiary case file and the testimony of both the town's code enforcement officer and as well as the respondent, that the respondent's in violation of section 92-010A. I'm gonna require a respondent to comply with that section within 70 days, or $100 a day fine will be assessed for each day that the violation continues. So I'm giving you essentially 25 more days, almost a month more than they asked, just to make sure you get through the county's process. If there is anything that causes you any delay, make sure you keep in touch with the town, because if you do come back before me for a fine assessment hearing, bring all of that evidence with you. So if you've called the county every day from today's hearing on until the next hearing, I'll take that in consideration in terms of whether I give you additional time at the fine assessment hearing. So just keep a log as you go forward. Hopefully 70 days is plenty of time, and with all due respect, I don't have to see you again. But if there is any hiccup, make sure you communicate with the town so that they understand what's going on.
Do you happen to know what date that puts us at?
I am figuring that out
Okay.
right now. So that would be the May hearing. Is the town proceeding with Monday hearings, first Mondays of the month? Is that correct?
Yes.
Okay. So that would be the May 5th hearing, fine assessment hearing if necessary. Actually, hold on, let me see if April might actually work. Might actually fall. Yeah, the town attorney, can you get me the April date? While I figure out what 70 days is. No, it's gotta be May.
And that would be, the hearing would be April 7th.
Okay, yeah, the 70 days gets compliance by April 14th. So I'll have the order actually specify the date. It's 70 days, but it'll say comply by April 14th. And I think that's easier. Let me ask the town code officer, going forward, when you make your remedy request, if you can have the actual date instead of 30 days, 60 days, that way the order is very clear.
Yes, Your Honor.
Perfect. All right, so with compliance by April 14th, in the event of non-compliance, you'll have to appear before me at the May 5th, 2025 fine assessment hearing. And then again, in the event of non-compliance, I'll assess a fine of $100 a day for each day the violation continues thereafter. So as I said, if something happens, keep in touch with the town. Bless you, and you can come back to me on May 5th and ask for additional time if you need it. As I indicated, the town does have hard costs for today's hearing, and since I have found you in violation, I'm going to assess the administrative costs for today's hearing in the amount of $234.05. Bless you, payable within 30 days. Best of luck to you. I hope, again, everything gets sorted out in those 70 days.
I appreciate that.
Thank you.
Thank you, guys.
Thank you.
All right, next.
Your Honor, we are now on item 6A, and that is for under fine assessment hearings, and that is for Roberto Perez and Maria Fonte. The property address is 3384 C Road, Loxahatchee Groves, Florida. The case number is 230600006.
For the record, Code Inspector John Suarez presenting case 2306-0006 in reference to the property 3384 C Road. The service for notice of hearing was sent via certified mail on January 17th, 2025. The property was posted with a notice of hearing via certified mail, January 17th, 2025. The notice of hearing was also posted here at Town Hall. There's a signed affidavit of service in the case folder as well as photos attached to the postings. This property was initially cited on June 12th, 2023 for the following violations. Section 05040 AB, work without permit. Section 175170, FDA violation. And section 175240, section 175110, FDA, needing an FDA permit, site plan permit. The initial special magistrate hearing was on June 19th, 2024, where the magistrate found where there was a finding of fact the violations existed. The property owner was then given until August 16th, 2024 to come into compliance.
Well, hold on. It was a finding of fact or was it finding a violation?
It was a finding violation.
Okay.
So the property owner was given until August 16th. Essentially, that was 58 days to come into compliance. The case was then heard on November 4th, 2024, where the magistrate granted a continuance until January 10th, 2025. So this is having to do with a site plan permit, FDA permit. And after review of the permit, the property owner did resubmit the permit. He submitted corrective plans on January 22nd, 2025. And the town says they need till February 5th to 2025. I have been in contact with the property owner. He's in good faith. He's trying to get the FDA. It is time consuming, and it's in the town hands now to review for it to be approved. He could not make it today, but he's asking for another 90-day continuance. He is working. The town is not an objection to that.
Okay. All right, so. So that would be on track for the April 7th hearing. Comply by April 1st. Is that acceptable to the town?
That is acceptable.
Okay. All right, do you have the evidentiary case file? Thank you. Thank you. And the gentleman knows that you're giving, he asked for the 90 days, is that what you said?
Yes, Your Honor.
Okay, so he's in agreement or she is in agreement with that. All right, anything further?
Nothing further at this time. For the record, I have been speaking with Roberto Perez, I believe.
All right, in case 23060006, I'll enter the town's evidentiary case file as composite exhibit 1 without objection, noting for the record that the respondent is not present. I'll find based on the affidavit of posting that the town had good service for today's hearing. I'll grant the mutually agreed, I guess, first let me state that based on the testimony of the town code officer that the respondent remains in violation of section 05040 AB, 175-110, 175-170, and 175-240. I'll grant the mutually agreed continuance, establishing a new compliance date of April 1st. In the event of non-compliance, I'll require appearance at the April 7th fine assessment hearing. I'll maintain the previous fine amount, which was $250 per day in the event of non-compliance. And I'll reserve administrative costs for today's hearing. All right, thank you.
Thank you, Your Honor.
Your Honor, we are now on item 6B, and that's with property owner D&D Fine Grading Incorporation. And the address for that property is 13961 Okeechobee Boulevard, Waxahachie Groves, Florida. And that's for case number 24020010.
Good morning, Your Honor. For the record, case 24020010 has been complied. It was a late compliance. They had to get a permit and the permit is now, it's now paid for and issued.
All right, so you're requesting to pull that?
Yes.
Okay, thank you.
Thank you.
Your Honor, we are now on item 6C, and that's with property owner SQ Farms LLC. The address is 1300 D Road of Loxahatchee Groves, Florida, and it's case number 24060020.
Your Honor, for the record, Code Inspector John Suarez presenting case 24060020 in reference to the property at 1300 D Road. The service for notice of hearing was sent via certified mail on January 17, 2025. The property was posted with the notice of hearing on January 17, 2025. There is also a posting here at Town Hall. There is also a signed affidavit of service in the case folder as well as photos attached of the postings. This property was initially cited on June 21st, 2024 for the following violations. Sections 30-6, keeping of fill on the property. That was actually complied. Section 20017, prohibited use. Section 20010, outdoor storage. Section 20010 G1, outdoor storage. The property owner was given until July 16th, 2024 to comply. There was a reinspection on August 20th. And the violations observed it was still in violation. The case was then brought before the special magistrate on September 18th, 2024, where the magistrate found sufficient evidence to support the violations exist as cited at the notice of violation. The property owner was given an additional 90 days to comply. There was a reinspection by myself, Code Inspector Neonakis, and Public Works Superintendent Lauer on January 14th, 2025. The violation still existed. The property owner and his attorney were present for that reinspection. I did observe the fill was removed, but there was still outdoor storage of trailers, containers, and other miscellaneous items that did not have to do with their ag classification, which is equestrian. There is evidence of a hay transfer business on the property at time of inspection. There were multiple trailers of hay as well as hands to distribute or store
As
that.
well as what?
Work hands.
Oh, people. You mean people,
yeah.
okay.
I have been good, me and the owner and the attorney, they've been good with email contact. Um, they have emailed even this morning stating they're in compliance, but I need time for reinspection. In addition to my testimony, I offer the town's code enforcement file for case 2406-0020's composite exhibit to be admitted as evidence to further support the finding of violations for code sections 2017 and 20010G1. At this time, I know the attorney's here and let him speak.
Let me see the case file, please, first. Let's deal with the easy part before we get to the hard part.
Yep.
Thank you. And you, sir, I think, came in after I did the swearing in. Do you want to be sworn or are you here?
Yeah, sure. I would like to be sworn in since I was president at the time of the meeting.
Thank you. Do you swear from to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor. I
Thank
do.
you very much. Give me 1 second to go over the case file and then I'll get your appearance. And we'll get into the good stuff. And I don't think I heard the town give its remedy. Does the town have a remedy that it's seeking, or would the town like to hear from respondent?
The town is not opposed to a short additional time because we have been in contact. They did say they would they'd clean up all the outdoor storage and remove the transfer station, all the hay, all the storage of hay. So the town is okay with 7 additional days. If it's still in violation after 7 days, $100 for each violation the town is asking for, and administrative costs of $234.05 to be assessed in order to be paid by the town to the town by March 5th, 2025, essentially 30 days.
I guess because this was several months ago at this point, what was the use issue at the violation hearing? Was hay part of that, or is that new?
It was part of that, but they also were sifting. They were bringing in fill and sifting and grading, which is just prohibited use also, as well as a hay transfer. So at the time of when we were there, January 14th, the sifter was still there. And I think they were in the process of removing it.
Okay, let me ask you, Mr. Suarez, to give this to the attorney who's gonna give me his name here. Go ahead and give me your names for the record.
Reginald Stambaugh on behalf of SQ Farms.
Well, I'm sorry, repeat your name?
Reginald, Reginald first name.
Okay,
Last name Stambaugh, STA, M as in Mary, BAUGH.
okay,
With my own office.
okay,
And I represent SQ Farms LLC, and with me is Mr. Qureshi, who's the client, who's been in close contact with Mr. Suarez, and I can tell you that Mr. Suarez has been a pleasure to work with in trying to get these things resolved since I stepped in. And they were actually, in my understanding, that they were actually trying to get an 11 o'clock time or a time on Friday, and there was a logistical issue on meeting on Friday. But we're here today to attest to the fact that we're in compliance. We brought photographs, and we just ran out of time in trying to coordinate. We were trying to get there at 8 o'clock this morning to see, because the hope was that we would meet on Friday. And when we met originally, there were indications by staff that it would be closed out. We wouldn't even have today's hearing.
okay.
I appreciate greatly the additional 7 days, because I think, Mr. Suarez went there even today, he would see we're in compliance. So we're encouraged by, the staff's, again, willing, cooperation, to give us those 7 days to prove it out. The only outstanding issue would be if there is a determination by staff that we're still in violation at the end of the 7 days, that we would be able to, question that if in fact that's true, because I wouldn't want to concede to just a unilateral, determination that we're in violation if we believe that we've done all this work, and Mr. Curation, be better for you to hear from him, all the things that we could proffer to you, all the things that he's done up until today's date, because the hope was that we would be able to be on Friday.
Okay, let me do this. What is your name, your first name, sir?
Shamir Qureshi,
Spell it for me, your first name?
Shahmir.
I would not have gotten that right. So thank you for that. Let's do the easy part in terms of the documents, and then I'll hear from your client. Do you have any objection to the evidentiary case file that the town would like to enter into the record?
I have no objection.
Okay, so and you don't have any exhibits that you want in the record?
We just have photographs to show what the property looks like as of today. I can email them to you or text them to you. They're on the iPad. They were literally taken 1 hour before today's hearing to show the latest and greatest condition of the property. We did provide them to Mr. Suarez briefly in between cases. He may want to question them or ask, but I would just like to proffer them to your honor so that you can see that a lot of work has been done between the time we met and today.
Okay, so let me do that. I guess, if you have them on electronically, I
Yeah.
guess, and you've already emailed them to the town, is that your testimony?
No, we haven't emailed them.
You have not emailed them.
Right, but we
Okay.
can email them to the clerk and to your honor.
All right, go ahead and look at those, Mr. Suarez, and your attorney as well, if she wants to take a look.
The only thing I might add is that it does not include the photographs of all the horses that are there that were eating the hay that was stored there. And cows. I keep forgetting the cows.
So Your Honor, it looks greatly improved. They removed a lot of storage, a lot of the hay. I do see some trailers here, but they even look not as full as before. And they do have horses on property. So a little bit of hay or hay just for their horses is fine. So I do have to re-inspect, but it looks like it's vastly improved. I just have
Okay.
to go there myself.
And what's your response to his statement that there was supposed to be a meeting on site on Friday? Was that
We-
not able to occur?
We were trying to coordinate, I guess the entire week, and he needed a little more time, and you might have emailed me Friday. It's just we were so busy Friday, I could not get out to his property.
Okay. All right.
And Special Magistrate, just for the record, no objections to those photos, but of course, the code officer would need to re-inspect and take his own photos.
Sure. All right, let me ask you to show me those since you showed the town. Let me see your
Yeah, sure.
photos on there. And how many photos is it?
If Mr. Qureshi took the photographs and he's here to test, let's see. There's
Six photos.
one,
Maybe
Two.
7.
3, 4, 5.
Okay, so 6.
These are scroll through them and I'll-
No, that's fine. I just looked at them. You can take that back.
Okay.
All right, so with that, and let me ask the code officer to get the town's case file. And I'll ask that you email the town those photographs so that they have it for the record, because I'm gonna add them to the evidentiary case file. So with that, in case 240600020, I'll enter the town's evidentiary case files composite exhibit 1 without objection. I'll also enter respondent's 6 photographs, mark them once they're received by the town. I'll ask the town to put them in the case file marked exhibit R2, including the 6 photographs that were taken by the respondent. And those were taken today, sir?
Yes, this morning.
This morning, okay. All right, so Mr. Stambaugh, I think I heard your agreement with the 7 days. That's enough time to coordinate another inspection.
Absolutely.
So compliance by next Monday
Absolutely.
essentially is what my order will reflect.
Thank you.
Okay. And then I don't expect this will be necessary, but in the event that there is an issue and compliance isn't established before February 10th, you'll have to come back to me on March 3rd for fine assessment hearing. I don't again expect that'll be necessary based on those photos. It looks like you're
Hopefully I won't see you again in
with
this
all due
capacity.
respect, that's right, with all due respect.
With all due respect.
All right, anything further from either party?
Nothing further here.
All right, with that. In case 2406020, I've entered both sides evidentiary records. I'll find based on the affidavit of posting in the town's case file, as well as the testimony of the code officer, that the town had good service for today's hearing. I'll find based on the documents in the case file, as well as the testimony of both sides, that the respondent remains in violation of section 20-010, G1 and 20-017 by virtue of the fact that the town needs to do a reinspection. It looks like based on those photos, they're very close, but without the code officer having been out there, I'll grant additional time to allow that inspection to occur and hopefully comply you out. So with that said, I will grant the mutually agreed continuance, establish a new compliance date of February 10th. I'll maintain the prior fine amount, which was $250 per day in the event that the violation continues after February 10th. As I said, in the event of non-compliance, you'll need to come back to me on March 3rd for a fine assessment hearing. And I'll reserve administrative costs for today's hearing, given the fact that the parties were working to try to get this resolved, but didn't prior to the hearing in terms of an inspection. So I'll reserve those costs. And you'll get an order that reflects that, okay?
Thank you,
you.
Your Honor.
Thank you.
Thank you, Your Honor.
All right. Anything further?
Your Honor, there is nothing further on continuances, but we would like to note that our next hearing is scheduled for Monday, March 3rd, 2025 at 9 a.m.
Duly noted. And I guess just as a matter of procedure going forward, so the Wednesday hearings are canceled going forward, is that,
That's my understanding. from
Okay.
town.
can you confirm that with the town and and send me an email? Just, I'll keep them on my calendar, but if they're not gonna happen, let me know and I'll take them off my calendar.
Okay.
If
I'll
you
send
could.
over calendar invites too.
Well, take them off, I guess. I have them on there because you were previously having a Monday hearing and then a
Mhm.
Wednesday mid-month hearing. So
Okay.
confirm whether or not the town is proceeding with the Wednesday mid-month hearings and let me know either way. So if you're not intending to use those dates, I'll remove them from my calendar.
And that is my understanding. I know we're working on a calendar. I've heard from the town manager that, or at least they've confirmed that it's only Monday, but
Okay, yeah,
So
if
we'll-
you can, yeah,
Yeah.
I'll keep them on there until you tell me otherwise,
Okay.
but if it, I appreciate that you reached out before this hearing, because sometimes I get, is there a hearing or is there not? So if you're not intending to use Wednesdays, just let me know. If you are, that's fine. I'll keep them on the calendar.
Okay.
All right, hearing nothing further, I'll adjourn this hearing at 10:20.
Yeah, I can do that, that's fine.